Hey y'all, welcome back to my channel. If you're new here, you feel like you got a little bit of that common sense that's not so common, go ahead and hit that subscribe button. And if you don't, please hit the subscribe button. We're trying to, this is a disease. It's contagious. Hit the subscribe button. You will catch it, okay? Today on our channel is going to be another Common Folk Perspective video, but it's going to be for bills that are currently pending in South Carolina. Now, these are juvenile bills that are amending how juveniles enter into a juvenile detention facility, specifically for first-time offenders, okay? Remember, I don't have any law degree and I don't have any official law training, so don't come for me. And before we get any deeper, first and foremost, my name is Key, and this is What's the Key?
For me, break for me, break the body for me.
All right, y'all, let's get right into it. As always, if you see me looking to the right, I'm looking at my notes and any bell you're hearing or any tail you see, because my cat is right here. City's right here. Is my cat City doing kitty things, okay? Now, South Carolina's juvenile bills. All right, look. Y'all, I was looking through the good old ACLU, the American Civil and Liberties Union website, the one for the people. And I stumbled upon them being very upset with South Carolina, specifically the Department of Juvenile Justice, okay? They are suing the Department of Juvenile Justice, all right? The federal government has been complaining about South Carolina's Department of Juvenile Justice, okay? At this point, if you know anybody in South Carolina, they probably know somebody that is upset about the juvenile justice system in South Carolina. That is just how it seems from this article. They seem like they have been under scrutiny for years, and ACLU is definitely not letting their foot off their neck, because they recently just had an audit. Recently, when I say recently, at the end of December 2024, and they ain't really showing as good as progress as you would want to see, okay? So let's get into it. ACLU has said that this recent audit that has been released shows that youth are routinely alienated, victimized, and traumatized, okay? Y'all, it's bad. It's bad, okay? So I told y'all they were receiving a lot of federal scrutiny, right? So at the end of 2024, a new state audit was released, and out of the 101 recommendations they were getting, only about half of them have been implemented, okay? And then out of the 24 safety recommendations that they were given, 8 had only been implemented. So the DJJ actually fought back with this, and they stated we actually did implement way more than what they are saying. The half of the 101 recommendations, and out of the 24, the 8 say there's we implemented a lot more, but we weren't able to interact with the auditors in any type of way while they were going through the facility. Now, I know from firsthand experience, if they not interacting with the auditors, then it can't just be a one and done situation. You do need to hear explanations if you see that something is not implemented as to why it is not implemented from the horse's mouth while you're in the facility. Like I said, I know firsthand, even just between the COs and the HR department at DJJ, I know for sure in Illinois, you struggle to get them to understand that, hey, this is actually something that is serious until they have to experience it themselves. So with them not being able to engage directly with the auditors, I know some people may think, oh, they could be trying to manipulate them. No, they're not going to manipulate the auditors. The auditors are going to have what they said. But if something is unreasonable to implement, or they did some type of alternative that isn't exactly what was recommended, but is a good alternative, then I feel like the auditors should hear them out and listen to what they have to say.
Makes sense to me.
I can tell you right now, some of the stuff pushed down from the state, from higher ups, is not very safe from the CO officers. And y'all will see that with this high turnover rate. So the audit team reviewed 118 people when they were there 1 year ago. And out of those 118 people, 93 had left. They had only been in there for an average of 3 months. Okay, y'all, it is real. That makes about a lot of sense. Okay, and I don't know, I didn't look specifically into the audit. I don't know what the state is asking them to do, but like I said, I know firsthand a lot of stuff that's pushed up from the superintendent at the facility and from the state is shit that is very, I'm sorry, y'all. Sorry, my older generation. It's stuff that is very dangerous for CEOs to have to implement and have to deal with. I do think they need to do a better job at dividing the youth between the ones that do need stricter push secured confinement and the ones that are just in there for like little small misdemeanor nonviolent offenses and etc. And that is what these South Carolina bills are kind of getting into. So we're going to get into that in a bit. But there was a University of South Carolina law professor, Madeline. Oh, y'all, I'm going to mess this up. First name Madeline, last name starts with a W. I'm going to put her name in here. She stated, we do need to look at the back end resources. So the back end resources, we do need to look at how the detention centers are ran, how the rules are implemented, et cetera, et cetera. But you also need to look at the front end resources as well. And those front end resources that she's talking about is what cases that we decide that the children get implemented to juvenile detention center for anyway. So she brought this up as well a year ago, and they definitely heard her because now they are pending. There's 2 pending bills in the House and the Senate that are looking for alternatives to juveniles going into the system that, 1, keeps them from having a record, and 2, keeps them from being mixed in with maybe those juveniles that are doing harsher crimes. Okay? One thing I could not stand being in there firsthand was seeing someone come in for something as simple as selling ganja to college students being mixed in with a person who has unalived someone, okay? A person who has repeatedly been in there for multiple assaults. When, at least in Illinois, back in 2017, 2018, there was not enough division. There should never be a case. I don't care if the youth gets in trouble while they're there. There should never be a case where you're mixing up non-violent offenders with violent offenders. You know what happens? Violent offenders start to manipulate the non-violent offenders. And then non-violent offenders go with it. Why? Because they're not aggressive people. They're not going to fight back. They don't want to get hurt. Okay? Now the non-violent offender is doing a bunch of BS, or a first-time offender doing a bunch of BS, getting themselves in more trouble. Now their short 1-month sentence is now a year because of all the additional things that they did inside that got extra time added on. So I feel like the juvenile justice system does very much need to do a better job at separating violent offenders, those reoccurring offenders, from those non-violent and them first-time offenders, okay? And that's why I really, really like these South Carolina bills. And I wanted to talk through them with y'all because it's needed. Some of these youth should have never even made it into a detention center in the first place to get it, and they come out worse. There are a lot of youth that come out worse that are first-time and nonviolent offenders. Why? Because they were getting a butt whooped in jail. They were getting intimidated, manipulated. You got staff who get intimidated and manipulated. Some of them can't even stand their ground, and that's why a lot of the new ones quit. Is because if you're not following policy and procedure, but y'all want us to come in and try to push in policy and procedure, it's not gonna work. It's just not going to work. And the staff that usually stay in there the longest are the ones that are easily manipulated, the ones that are working outside of the rules or doing whatever they have to do to keep themselves safe and to keep that paycheck, because they do get paid pretty well working in these detention centers. So, but I don't feel like any of it is worth you becoming harmed and hurt. And that's another thing that's not talked about. Like, yes, the back end, we need to get all this other safety measures in place, but are we protecting the COs? And I asked that, and we'll get further down, and y'all will see exactly why I'm asking that question, because that's going to be your biggest problem. If the CEOs don't feel safe where they work and you have a high turnover rate, you're not going to get any consistency inside the facility. Moving on. Oh, something else that Madeline talked about was the fact that a lot of school offenses should not be in the facility, like truancy and things like that, and I agree. Why are kids being locked up for things done in school when a school can implement their type of discipline? All right, now if it becomes something repeated, and they're just wreaking havoc in the school, then we can look at alternatives. But the school should be handling school offenses, okay? We shouldn't be arresting kids from school and locking them up in juvenile detention center. They get suspended, whatever. They could even have it to the case they get suspended, and now, okay, this kid's suspended from school and they're on home detention. So they have an implemented program like that. But stuff that happens in school should not be getting them same school kids locked up with some of these kids who probably stopped going to school in middle school, who parents never cared that much for them to continue to carry on. Okay? So yes, Miss Madeline, I agree. All right, so let's get into the first House bill, which is House Bill 3595. And this was sponsored by Representative Henderson Myers, who I believe is Republican. The bill was introduced on January 14, 2025, and both of these bills were introduced on January 14, 2025. So for the House bill, it's at least one juvenile pretrial diversion court of pre-detention nature must be established in each judicial court in the state to provide services to all children in all counties in that circuit for the purpose of offering an alternative to referral to the juvenile justice system for all children who commit first-time nonviolent as defined in section 16170. And y'all, let me tell you why I looked up 16170. And 16170 said basically anything not in 16160. 16160 was the one right above it. And it was just long list of violent offenses. So if you go look up their section 16160, if it's not listed on there, it's considered a nonviolent offense. All right? So each of these courts must be able to serve all of the available children in an area at no additional cost to the children. So the program cost, the court cost, none of that can be added in for the children, these first-time nonviolent offenders. All right? The Department of Juvenile Justice must establish, implement, and oversee this new program to which the first-time offenders are sent. So they said, we telling y'all what to do, but y'all gotta execute. Y'all gotta do all the work. Okay? Make us look good. The DJJ must also competitively supply the funding to one program in each judicial court to go alongside the funding they already have. So when I saw this part, I was wondering, like, is this gonna be another situation where you get to a point where one county's doing better than the other because the taxes are higher than the other, and now they're getting all the funding because their program's more successful. Why? Because they're able to get more funding out of their counties because of the higher tax brackets. And those other programs in those other counties who really, really need them, the lower socioeconomic status, I know y'all probably like, stop talking like that. The lower socioeconomic status will start to fail more. He says funding they already have. So I don't know if there's going to be general funding and then you can win additional funding. But yeah. We don't want a situation like that, okay? Because we know places with lower socioeconomic statuses are already going to be at a disadvantage. So the programs that do receive the funding from the DJJ must adhere along the standards and procedures that are put in place. This can include the requirements for applicants, organizational characteristics, reporting, and auditing criteria. Now, they said pre-detention programs can incorporate the following. My personal opinion, stop saying can or may and expecting people to do things. Because that's when you go back and you change a law and have to say must incorporate, because then they do the bare freaking minimum, just to be able to get funding, get the youth through, and etc. Okay? But they said pre-detention programs can incorporate the following: educational, academic, and vocational, mentoring, mental health, and behavioral health services. Okay, so those are all the services that they said can be incorporated. I don't see not one of them that should not be incorporated, especially in counties that are known to have a lower tax bracket. Law enforcement officers that takes a child into custody for nonviolent offenses must check the database for any juvenile record, and if there is not one, they must refer them to a local pretrial diversion court. So the court's gonna keep them from going into a detention center as a first-time nonviolent offender. So if the Department of Juvenile Justice ends up receiving a first-time nonviolent offender, they must deny it and send back to the person who referred it or the referral source that, hey, you're supposed to be doing this. And honestly, don't play stupid. We know there'll be a disproportion of Black and brown kids being sent into jail. Let's go ahead and penalize people who act like they can't take the time to search a database, and when nothing comes up, realizes this is a first-time nonviolent offender. Yeah.
Oh, yeah.
I like that. I'm all about having penalties behind things because I feel like that's what keeps people more accurate. I get human error. But there should be no human error of you searching a database and nothing pops up. And you don't know not to send them try to send them to jail. Don't give them more of a hassle. Be an a-hole. Okay? I've learned a lot from the mouths, from seeing it. Okay, don't play stupid. Penalize them if they do send it.
I said what I said.
Another thing is records from the pretrial diversion program are to be kept separate from the juvenile justice system. I love that. I love that. Okay? Because the first time offenders are going to a completely different program. They didn't make it to the detention center. So don't put it on the record as if they were a juvenile. I love it. I love it. A referral to the court is not a referral to the juvenile justice system, and they may not reflect on the child's criminal history. Okay? They said this because they had to go to court. Doesn't automatically make them a freaking convict. Each pre-detention program must submit at least annually the following for each child. And a lot of this stuff, they probably should just be getting it an intake, keeping it on file, easy peasy to submit. All right. Race, ethnicity, and gender of the child. Alleged offense committed, including the state number of the offense. The county the offense was committed, and the law enforcement agency that had contact with the child in the defense. I like that. I like that. Now you can keep track of which people and what ones are always trying to seem to lock up juveniles. Okay? And then any other info they requested by the Department of Juvenile Justice. I love it. I love it, though. I love it. It's like, and anything else we decide to ask at any given time. So keep your notes. The child's counsel or the parent or legal guardian must be notified by a law enforcement if they are eligible or involved in the pre-detention diversion program. Also, the parents must consent, although they are not obligated. Okay? Now, parent must consent. Not obligated consent. I need a little bit more detail, meaning we can still put them in that program regardless if they're parent to consent, or if the parent says no, then this child's not in the program. Then I need a pushback for that. You said no, okay, now we taking you to parenting classes. Yes, ma'am. Because we going, something ain't right. You think you're not doing nothing? The kid's about to be locked up. So, if the child does recommit, okay, then, like, I feel like we should say they're a first-time offender. If the parent says no, and then the child does recommit, I feel like it should be seen as a first-time offender if they didn't go into that program. I need a little bit more specifying. But like I said, this is very early. We looking at the bill brand new, y'all. And this will be one I track because I'm really interested in this bill. But yeah, overall, I need a little bit more detail on that because my brain is going to multiple perspectives and I need it broken down a little bit more, okay? And I'm really hoping it really means that their consent doesn't matter. And if it does matter, then their next step should be sending them to parenting classes, like I said. And if the child does recommit, they should go back as a first-time offender and be allowed into the program. I need a little bit more detail on that, South Carolina, if you ever see my video, okay? And they may participate for 3 to 6 months with an additional 6-month extension for a total of 12 months after a notice and hearing by the pretrial diversion court upon request of the DJJ. Okay, so in order to add anything more than 6 months, they have to get it approved. But 3 to 6 months should be around the average time the per child is participating in the program. I do like that they put a limit on it. Like, nigga, don't be having people in here for 5 years. And then y'all done turned this to another way to being in jail. 3 to 6 months. You know, could be shorter. If it's longer, get approval. But they shouldn't be in there for more than 12 months. And honestly, they shouldn't need more than a year if they're a first-time nonviolent offender and you have educational, vocational, behavioral services, mental services, and mentors all in there. After 6 months, actually, I think a year would be solid. It'll help them get into a good habit and routine and feeling accountable and responding to somebody, even if 3 to 6 months is in their program and then 6 months out of the program, or it's like an outpatient type thing. I don't even know if the programs are like an inpatient type thing, but I guess that's for the states to decide when they create them. If there is a victim and the child and the victim agree to restitution, the court can order them to pay it independently, but it cannot be ordered as part of the program. Upon successful completion, the court must dismiss charges and they may not be reinstated at a later time. So if they go out and then they do become a little-headed child and just recommit stuff, you can't be like, oh, see, you just came right back. Now I'm about to add yours. Nope. They completed their program, them charges are gone. These are completely new charges. Omissions or statements made by the child as part of the preliminary to determine eligibility are not admissible prior to dispositional hearing. So, and you know what? It shouldn't be. They shouldn't be the same person if your programs are successful in doing what they're supposed to be doing, right?
Makes sense to me.
If prior to discharge, upon completion of the program, the child fails to fulfill the terms and conditions, the original charge may be reinstated and they may proceed as if they never entered the program. So if the child gets into that program, first time non-violent offender, and we just realize we got us a Chucky on our hands, we're going to act like we didn't even put them in the program. Send them back to the court, put them in a detention center. Into the House bill, that will take effect upon approval of the governor. Okay? Governor, and I'm not saying you got to approve it now. We got to add some stuff into there. But governor, there's no reason for you not to approve this once it's all amended and sent in to you. Let me tell y'all a story. The reason I stopped working in the juvenile facilities is because I realized I was at a point where I wanted to go back to school and find a way to prevent the juveniles from even making it to the facilities because the facility was so bad. And I was in 2 different facilities. The first one wasn't as bad, but as far as the DJJ, the detention center in the county was good. The DJJ was crazy. Okay, I was like, we have got to prevent them, find ways to prevent them from getting in here. Because once they're in here, they're goners. And like I said, with the mixing of the non-violent, like they're goners. So I literally left the facilities because I'm like, bro, we gotta find. I gotta find a way to prevent. And then I went into the mental health field. But these bills, like I said, I love them for that reason. Because you do. A lot of youth get in there, get worse, get traumatized, and victimized. Everything that ACLU is saying, I've seen happen. So yes. Thank you, South Carolina, for having this and imposing this. I'm mad it took y'all so long that everybody and their mama has to be on y'all ASS. But I am glad that y'all finally getting with the program. And I'm hoping these are bills that go into effect on July 1st. You know, the big chunk of July 1st bills we get, July 1st, 2025, I hope is when these bills go into effect. All right? So the Senate bill is Senate 266, and it was sponsored by Senator Hutto. It was introduced, like I said, on January 14, 2025, and juveniles must not be detained in an adult jail or other place for adults more than 6 hours is the first part of this bill. And I'm like, it had to become a law. That means it was happening. Y'all were holding juveniles in a facility with adults.
Death to all of them.
They also said if they are held there within that 6 hours when they are held there, they must be in an area where they can't hear or see the adults. Why the heck were the children hearing and seeing adults in the first place?
Does that sound like it makes sense? Does it sound like it makes sense?
I get going to the courthouse and being in the county. No, it's still not an excuse. They should have been in a completely separate area. South Carolina. And what's crazy is I feel like state of Illinois does have separate areas. I don't think I've ever seen a mix. I don't think they can be. They keep them separate. So South Carolina, why did this have to be made a law?
Fuck. Oh my.
That's even more corruption, coercion, and intimidation. Adults? I have seen in some cases juveniles go straight from juvenile detention to adult. Some of them people are repeat and don't care. South Carolina, I'm not finna play with y'all. Okay? I'm not finna play with y'all. All right? A child who was taken into custody for the violation of a law that would not be a violation for an adult must not be detained in an adult facility. It must be detained in a juvenile facility unless an order was previously issued by the court. And the first example that came to my head was like teens drinking. That would be something that an adult wouldn't get in trouble for, but a teen would because they're underage. I don't understand. Y'all were putting them in adult facilities. I'm saying if they had to put it in the law, it's most likely because it was happening. What is this thing of y'all want to put juveniles near adults? It's giving trafficking. Oh, that's what it's giving. Okay? This notice from the court will tell the child if they violate this order, they can be detained in a secure juvenile facility for no more than 48 hours, excluding weekends and holidays. Okay? So the children so once them teens, they get caught, whatever, they don't go to adult facility, they receive the order from the court. Okay, the notice for the court will basically tell the child that if they violate the order, then you will end up 48 hours in a juvenile facility. So they're making things that wouldn't be illegal for adults, but are illegal for children, not as harsh as a crime, not leaving them in there forever over something that as soon as they hit 21 won't be an issue. I get that. I get that because it is legal. It's just not legal for their age. And I get not having them. If you keep catching a child, I'm just thinking of the example of the drinking. If you keep catching them drinking, at this point, send them to rehab, not jail. Because why are you drinking so much at that age? Alcohol tastes nasty. Now, a status offender can still be taken into custody. And a status offender is just an offender who, like we were just talking about, a juvenile that committed a crime that wouldn't be a crime if they were an adult. So the name for that is status offender. So the official child welfare board, parent or guardian, public official, and care of the poor, recognized agents of an agency, association, society, institution, or a person with knowledge that the child may be a delinquent, pretty much everybody and their mama, the whole community, may institute a proceeding respecting a child. So any of these people can be like, hey, this is an issue. Maybe y'all not catching them, but they need to be implemented. Okay. Before the referral can be accepted from the people listed above and before a petition for the offense can be filed, the person or entity above must show documents that the parent or guardian has tried to resolve the challenges through family counseling, pastoral counseling, parenting improvement classes, or other family therapy services. If so, then the referral can be accepted. If not, then they have to do what I just listed. I love that. Don't just be bringing people to the courts like, hey, this child is this child is that. Well, what are you doing? What if they're just having a mental health problem? What if the parents just ain't ish? What if it's just you just don't want to deal with the child, don't want to deal with disciplining the child, okay? You had the baby unexpected in the first place, and now you just fed up with it. What if it's you? I like that the courts are pushing this back on the parents, okay? A child between 12 or 18 while under the court's jurisdiction for an offense that occurred prior to their 18th birthday or for conduct that was an act of contempt of the court where the prior order of probation or court order arose from an adjudication for a criminal offense may be committed to the custody of the Department of Juvenile Justice who arrange for placement in the correct environment. I'm hoping with the correct environment they know that this House bill is going to effect, so they know any of those programs or whether it's a detention center, etc. Okay? A child under the age of 12 cannot be in any type of institutional confinement. They shouldn't be. Simple as that. They shouldn't be. And honestly, I would almost up it to 13 and under. Wait till they get to high school before we're in institutional confinements. Middle school and younger, absolutely not. Okay? And then also, no child under 18 can go anywhere else except the custody of the Department of the Juvenile Justice. Okay, so like we talked about before, why were they even adult facilities in the first place? Why were they even near those? Now, before they commit a child, they should order either a community evaluation or they can temporarily commit a child to the Department of Juvenile Justice for a max of 45 days while they conduct an evaluation. Now, and that is called a residential evaluation when they're in the facility. Now, a community evaluation is equivalent to a resident evaluation. However, in either eval, they shall make a recommendation to the court on appropriate disposition prior to final disposition. Okay? So, they're equivalent. They have their own little things going on about it. But in either case, they have to make an appropriate disposition. They have to tell them, okay, this is what needs to be done when the child leaves. Exactly. This is what we recommend to happen for the best rehabilitation of the child. Now, the department is allowed a child adjudicated delinquent, a child named delinquent, a juvenile delinquent, All right, for a misdemeanor offense or violation of probation or contempt for any offense who is temporarily committed to the department's custody for a residential evaluation to reside in the child's home or community while undergoing the eval. And I love that. You know why I love that? Because y'all need to see sometimes exactly what these youth are dealing with. A lot of youth are a product of their environments. A lot of people are like, oh, it stops at 18. No, it does not just work that way. It does not just work that way. When you are constantly, repeatedly in this environment for 18 years of your life, and y'all think at the age of 19 that a lot of these youth are supposed to just become whole different people. Yes, in their community. I want you to see who they're around. Because I can promise you, for those people that try to fake it a little bit, for the APA accredited counselors and therapists, okay? Trust and believe, we see right past your foolishness. We didn't already stood outside the door for 15 minutes, 5 minutes, 10 minutes, doing paper, heard you yelling. We didn't already call the kid on the side saying, hey, about something, or a case manager has called them, and then boom, heard you yelling. Heard you being this. We can see the status of the house even when you try to hurry up and clean. And even if you are on your best behavior and the child that we're concerned about is on their best behavior, what if you have other children? Now we can see the behavior of how the other children are acting. Are they sitting down while you're trying to get this taken care of? Or are they running around amok and you constantly have to yell for them to be quiet? Okay? I love that it's done in the community, in the child's home. You can even see what's around them. Maybe they are trying to be a good child, but now you going down the street and you seeing all kinds of violence. You see people doing drugs. You see people just wreaking havoc in their neighborhood. Now, there can be exceptions to this. And one of the exceptions is if the judge deems that the child is a flight risk or a risk to public safety, then of course, no, don't put them out in a community where they're going to take off. Could be spending resources to try to catch them back. Or a risk of public safety. You don't want to put them there, and then they didn't walk outside, saw somebody they didn't like them, ran up on them, and now they wreaking havoc in the community. So yes, I do get that, but I do feel like it's the case that even though you don't bring the child out, there still needs to be a tour of the home or a tour of the community, an evaluation of the community without a child. You just write an observation. You just observing what you see in the community. I feel like that is very much needed. Okay? Now, the court may waive this if there is a previous residential or community eval, and I want a date on this, and I want it done now. And I want it done right now. Because that's about 5 years of them being in it, from a juvenile from 13 to 17, basically through the year of 17. I want one at least every year. I want one at least every year. Okay, don't be using me the same eval you done did since they were 14 and now they're back at the age of 16 or 17, almost 17. No, nuh-uh. Could be a whole different environment. What if they didn't moved? From 14 and 17, a person could have lived 6, 7, 8 different places, 9 different places in some cases. They probably not even in the same neighborhood as they were before. No, I want a date on that, and I want one now. And I want a new eval. It has to be dated within a year for that juvenile, okay? Because what if the juvenile got out, did good for a year, and then had to go back? Like, I need a different eval, and I need one paid within the last year. They also have, the court may waive, as it has been within the past year, that they were temporarily or finally discharged or conditionally released from parole, and the child's previous evaluation or equivalent information is available to the court. But when was that eval done? Because are they getting an eval for every new offense they can? No. I just need an eval dated within 1 year can be used. That's it. I don't need no temporary release. They were just released. Are they updating and amending that eval as they're in there? So they do initial eval, then when they're in there, are they updating it? Because in that case, then I wouldn't care. But if this is one eval being done in the child's home, the community, inside the jail facility once, and then calling it a day, then no, we don't need that. So if they do end up waiving these evaluations and things like that, then they receive a determinate commitment sentence not to exceed 90 days. So if you do just try to commit this child at the eval that seems to be, that they waive for, can't give them a sentence more than 90 days. I like that, because now they realize they had to put a safety mechanism in there, and they did, to not have you just being recommitted nonstop off one eval from years ago. So I get that. Okay, they shut me up. My bad. I forgot. I wrote all that in there. Okay, my bad. Okay, a child may not be committed if the child has been deemed a delinquent by a family court judge for one or more status offenses. Now, the child is in contempt of the court for violation of a court order to attend school or an order issued as a result the child's adjudication of delinquency for one or more status offenses. So they're like, hey, they don't get committed to jail off of one, doing crimes that adults will be seen as illegal, and two, anything that has to do with school, which is what Madeline was saying before. That the school can handle their own school discipline. Why are we putting them in jail with hard menaces to society? The release and revocation of release of juveniles adjudicated delinquent. They keep getting me, and I need to stop saying adjudicated delinquent. I can translate common folk perspective. Juveniles deemed delinquent or juvenile delinquents and committed to the department must be determined by the Department for Juveniles and the Board of Juveniles, okay? The Department of Juveniles adjudicated delinquent and committed after March 31st, 2007 for an indeterminate period for a misdemeanor or other than assault and battery of a high and aggravated nature or assault with intent to kill, and for juveniles who have violated probation for a misdemeanor other than assault and battery of a high and aggravated nature or assault with intent to kill. Now, with this March 31st, 2007 debate, I think they're trying to help juveniles for a good chunk of years back. Okay, so these juveniles, 2025, they would have just be 18 now in this case. So they pretty much are helping anybody that has just turned the age of 18, because it's 2025 now, 2027, 20 years, so around -2, 18. They're protecting the 18-year-olds that just turned 18 this year and getting their records adjudicated. Round of applause for y'all for that one. Round of applause for y'all for that one. That y'all are making sure to get a good chunk of juveniles in this. I love it, Senate. I love it. Now, the Board of Juvenile Parole for juveniles adjudicated delinquent and committed for an offense other than the offenses I just listed. So all those attempts to harm to somebody, the aggravated nature of assault, the battery, etc., they also cannot going to be released for any of these. And I really hope in this case that they're looking at the initial crime going in and now what happened once they were in there. Granted, some of these youth are probably going to have to be evaluated once they come out to make sure they haven't become menaces due to their lack of rehabilitation and keeping youth separate and apparently having them near adult prisons. But I hope we're really looking at that initial charge and not what happened, what's in there, what they had to do to survive, basically. A person that has been taken into custody for, charged with, and adjudicated delinquent for having committed a nonviolent crime may petition the court for expunging records relating to being taken into custody, charges filed against them, the adjudication, and the disposition. So everything related. They was never there. Poof, gone. A person may petition the court if the person has a prior adjudication for an offense that would carry a maximum of 5 years in prison if it was committed by an adult. So I guess adult offenses less than 5 years in jail, they can petition for expungement. And I kind of wonder what that is. I wonder if it's because between the ages of 13 and 17, that's about 5 years. And the term of, I don't know. I wonder what made them choose a maximum term of 5 years in prison if committed by an adult. Maybe it has to do with South Carolina's adult system, and maybe any crime under 5 years they know isn't that severe, or it has to do with just that was the time they were a juvenile. I don't know what made them choose that one. Y'all let me know in the comments if y'all think y'all know why they made them choose a max term of 5 years that are committed by adult. They can have their records be petitioned to be expunged. All official records related to be taken into custody, charges filed, the adjudication, and the disposition for committing a status offense must be expunged automatically. We love a good automatically, okay? Because why do they gotta go to and do all this work? Why do they gotta go and do all this work if the law says that it should be expunged that way? Do it. And I like that y'all can tell from the laws from when we had about the incarcerated, when we talked about the incarcerated firefighters compared to when we talking about juveniles. They do put a lot more things in place to help juveniles succeed as opposed to adults. must occur as soon as the person reaches 18 and successfully completed in dispositional sentences adjudicated and imposed, as long as they have not been subsequently adjudicated delinquent for, convicted of a criminal offense other than that for probation violation or contempt of court arising from a status offense. And I really like how they're making it that these offenses that you're committing when you're a youth that are okay when you're an adult, that you can get in trouble for, but they're not making it a criminal history. They're not like disabling a youth because of it. And also a probation violation. I love that. Y'all know that black and brown kids be picked on. All right? No matter how good that child's going to do, there are some probation officers that are not rehabilitating. That can go straight to, they're picking at them. They're finding reasons to get in trouble. What is the word I'm looking for? They're trying to induce, they're trying to antagonize them, okay? To get them to react and pick and stuff. So I'm glad that probation violation would not count. The sentence basically saying we know we can't trust the police officers like that, the probation officers like that, and what y'all do. So we won't let that hold up against them for getting their records expunged. And I like that it must be expunged automatically at 18. You know why? Because what? Because they turn 18, they go to college. And in college, you need to have internships and things like that. They run in background records, or even applying to college. They're running background records, and things like this are pulling up on a background could make them, one, be denied for college, be denied for an internship, be denied for a job. If they do chose to go a different route and they don't want to go to school, maybe a vocational school, even a technical skill, they could still be denied. You're definitely disabling this youth at the age of 18 if you don't expunge those records, especially for nonviolent offenses. So yeah, I like that they're doing this. I like that it's automatic 18. I'm glad that probation violations aren't worried about it, and I'm glad that they're not criminalizing you so much for doing all adult activities. Do that mean they need to get in trouble for a heck? Yeah. But it shouldn't be to the point that when they become an adult, they're getting in trouble because they were caught drinking at 16. If you keep repeatedly catching this youth drinking at a young age, how about we send them to rehab and not the detention center? Okay? Capiche? All right. Now, if they are taken into custody for, charged with, or adjudicated, or deemed an adjudicated delinquent for having committed a nonviolent offense, the court may grant an expungement record. Okay? Now, any number of offenses for which the individual received youthful offender sentences at a single sentencing proceeding for offenses that are closely connected and arose out of the same incident may be considered as one offense and treated as one conviction for expungement purposes. So if they robbed somebody's house during the daytime, nobody was home, they got breaking and entering, they got theft of, stolen property, they got a broken window, so damage to the property, and then they got running from the cops, lying, all related, one thing, expunged. I love it. It's almost like if they walked into the courtroom, anything that y'all was saying at that time when they initially walked to the courtroom for their charges must be gone. I like it. We ain't got time to treat it one thing at a time. Now, they should not grant expungement unless they're at least the age of 18 years old and they have successfully completed any dispositional sentence imposed. They cannot at the time be subsequently adjudicated for or convicted of a criminal offense, and they do not have any criminal pending charges in family or general court. Okay, so they got to be 18, nothing pending, nothing holding on. Okay, you don't want nothing from the prior coming. And yes, this could be one of those things that, if they haven't got their act together, they don't need their record expunged. Yes, but it can also be in the case of, we ain't trying to do this 50 million times. So by 18, make sure everything from your juvenile is figured out so that when you go to the court for this expungement, we can just do it. It's automatic anyway, but when they turn 18, they may still have some things pending. So it won't be automatic for them. Now, if they were found not guilty in an adjudicatory hearing in a family court, they can petition for an expungement order regardless of age. They don't have to wait till they're 18. Why? Because it's dismissed. Take it off the record. And they must not be charged. Why do you gotta put that? They were found not guilty. Were y'all given charges even though they were found? But it must not be. Why did I write that? If I wrote that, it's probably because it was in there. Maybe I misinterpreted something. That's why I say with my secondhand bias too, you always gotta go back to the original source, even with me. Even with me. Okay? But not speech. Why we gotta say that? Shouldn't it be a little common sense?
Makes sense to me.
An adjudication for a violent crime must not be expunged, and I don't think it should. I don't care what it is, I don't think it should. I feel like a lot of cases, if it's explainable, it's explainable. But violence is usually not. And also, I just think, not even from a law enforcement standpoint, from a mental health standpoint, yes, we want a record. If you're going to have this person in having counseling and therapy, we need a record of the violence. If they become an adult, we need to know, yes, this was happening in their childhood too. If they're going to therapy. We're going to therapy services and we're really trying to rehabilitate and give these people second chances. We need to know that this was a pattern. And this bill will also take effect upon approval of the governor. I don't see why the governor wouldn't approve any of these bills. Right now, yes, they need to be amended. In which they are. These are early. Like I said, they were just released January 14th. It was just introduced. They are editing them as we speak. They probably have something new edited now as I'm talking about this bill today. But I don't feel there is any reason that the governor would not approve these bills. Especially you got federal scrutiny. You got the ACLU on your butt. You got probably everybody in South Carolina on your butt. And that just kind of reminded me, I remember there was a state, and I want to say it was Arizona, that believed that all they need to do was just release these juveniles.
Shut up! That is so stupid.
They wanted juveniles just to be released from juvenile prisons. They didn't want prisons anymore, etc., etc. Now listen, I get it. We need to rehabilitate our youth. But those people who were saying this clearly just think all parents know what they're doing. They also assume all these kids have homes to go to, so that none of these kids would be orphans or people off the street, that none of these parents would be non-decent parents, okay? Like some of these parents would actually care that their youth's out, that people would be able to force them into programs. Like when I saw that article, I was like, oh, y'all a little slow. Y'all clearly have never had to deal with menace to society, because in some cases, yes, the youth is a menace. And if we let them out to society, y'all be running for your lives and crying. Some of them couldn't wait to get free just to commit another crime. Okay, so I remember I saw that some time ago, and I was like, oh, y'all got it. Y'all assume that everybody is living this perfect little life. Okay? Some of them juveniles coming from orphanages. Some of them juveniles are coming from parents that don't care. Some of them juveniles are in there because their parent was well aware that they were selling Uggs. Do you think they cared? No. Why? Because the parent was getting a little bit of moolah out of it. Some of these parents need parenting classes. Some of them ain't got a backbone. Why is your 6-year-old yelling at you and hitting you?
Just makes no fucking sense.
Let us know. These are some of the parents y'all are sending these children back out to. Some of these parents are scared of their kids, and they've been scared of their kids since their child was like 3 or 4 and threw a temper tantrum. Now they're scared. Some of the parents act like they don't even see the crimes that their kids commit. Like they don't know that they're, and I always said this, when I build my little community, okay, and y'all let there be one, I almost need to own the land, because let there be one kid running around bad and we tell you that your child isn't doing, you are gone from the neighborhood. What you won't do is tear down our whole neighborhood and make it violent and stuff because you act like you don't see your little rugrat running around wreaking fucking havoc.
I said what I said.
And you don't want to do anything about it. Lock the parent up and put the child in the boarding school. I said what I said. That is what we need to do a lot more of, because a lot of parents are getting away with way too much of just basically having children, and when you're tired of raising them, you can just let them go, and then the children are just responsible for themselves and have to deal with all the consequences themselves, and the parents aren't looked at as if, bitch, is it you? Because it has to be you. Unless your child is showing that they have a big mental health problem, it gotta be you. Because even some of the most perfect parents, yes, you're perfect in the idea of what the general society thinks of parents are perfect, but are you perfectly tailored to your child? Are you perfectly tailored to the human being you are raising? That is the question. All right. But y'all, that's all I have. I done gave y'all most of my thoughts throughout the video. So let me know y'all thoughts in the comments about these juvenile bills. Like I said, I think it's great that they're offering alternatives to all these juveniles entered into the facility and for them getting their records expunged. But let me know y'all thoughts in the comments. I'll talk to y'all later. Bye.
For me, break, break, for me, break the body for me.